Hi everybody, thank you for watching this video produced by CMM Legal Services. CMM Legal Services is a elder and disabled estate and special needs planning firm located in Andover, Massachusetts and representing clients throughout the state. All of our contact information is going to be listed at the end of this video, so if you have any questions or concerns or feel that CMM Legal Services can assist you or your family, please give us a call and we will do whatever we can to assist. Before we get to the video, as always, we've got to go through the legal disclaimer. It is 3 paragraphs long. Please read it. It's very important. I'm not going to bore you by reading the entire thing out loud, but I will go through some highlights. So this is an ad for legal services, and it should be used for educational and or informational purposes only. This video was created in August of 2021. So at the time you're watching this, the laws may well have changed, and you want to consult with an actual attorney before you make any assumptions. And along those same lines, don't use this video as a substitute for the judgment of an actual live attorney. You're watching this does not create any attorney-client relationship between you and or CMM Legal Services. And again, along those lines, please don't send or share any confidential information with us unless you've spoken to us first and we have asked for it. So today's video is going to be about how MassHealth handles the assessment of assets between a married couple when trying to determine one spouse's eligibility for MassHealth's long-term care benefits. You may have remembered from the last video I said we'd be getting into strategies, but I think before we get there, it's very important for everybody who's watching this to understand exactly how married couple assets are treated when a couple is trying to get one of the spouses on MassHealth and or Medicaid. In 1988, Congress passed something called the Medicare Catastrophic Coverage Act. And what that did was it dramatically changed the way that MassHealth and or Medicaid is going to view the assets that are held between a married couple and determining how those assets are going to apply to each one of the members of those couples when one spouse needs long-term care benefits under MassHealth and or Medicaid. And what the law did was it basically said that in most situations, a married couple is going to be treated as one financial unit, meaning that any asset that the married couple has, whether they hold them individually or jointly, are going to be considered equally available to each spouse when it comes to MassHealth and or Medicaid's long-term care benefits. Now, I said that in most situations, a married couple is going to be considered one financial unit. There are two caveats to that, and that's that the couple had to have been legally married and living together prior to the date institutional care began. So as long as those two conditions are met, MassHealth and or Medicaid is going to look at the couple as one single financial unit when determining eligibility for long-term care benefits. So in situations where a married couple has been separated at the time one of the spouses needs institutional care, what MassHealth and or Medicaid is going to do is they're going to consider the assets of each member of that couple as available equally to one another until the end of the calendar month in which they became separated. As many of you are likely aware, Massachusetts was the first state in the United States to legalize same-sex marriage. And as a result, beginning in 2009, the rules we just talked about regarding married couples' assets and how they'll apply to one another in determining MassHealth and or Medicaid eligibility was extended to those married couples of the same sex. So now that we've talked about the ways that MassHealth and or Medicaid is going to view the assets of a married couple when one spouse needs eligibility for Medicaid's long-term care benefits, now that we've talked about that, let's talk about one of the first questions I'm often asked, and that is, when exactly is MassHealth and or Medicaid going to look at my financial records or the financial records of a couple to determine eligibility for these benefits? Because as many of you are likely aware, bank accounts change in value, assets rise and fall, IRAs can change all the time. So when exactly do they kind of freeze everything and determine what we had and how that's going to work with the eligibility? And the date that MassHealth and or Medicaid is going to use is called a snapshot date. And it's called a snapshot date because that's essentially what they're doing. They're taking a snapshot of your financial records and using those as the assets and or income that are available to a married couple at the time one spouse needs institutionalized care. When I say institutionalized, it really means basically any type of long-term care, nursing home, inpatient, rehabilitative care types of services. So it's pretty broadly applicable. Now, if you watch my prior video, you may remember that when a married couple is applying for MassHealth long-term care benefits, and only one of the spouses needs those benefits, and the other one's going to remain at home in the community while the other spouse is receiving care. In those situations, MassHealth is going to limit the applicant spouse or the spouse that's receiving the long-term care benefits to no more than $2,000 in total assets. And they mean it. $2,000, that's it. If you're a dollar over at the beginning of a month, your month's benefits are going to be gone. So it's pretty strict in terms of the applicant or institutionalized spouse. But the community spouse, or the one that's going to remain at home, is allowed to keep well over that $2,000 asset limit. This is because MassHealth has something called the Community Spouse Resource Allowance. And what the Community Spouse Resource Allowance does is it sets the maximum amount in total assets a community spouse can maintain and retain while their institutional or applicant spouse is receiving long-term care benefits. Now, the maximum is obviously important because it sets the upper limits, but the minimum is really important because in situations where a married couple do not have the minimum amount of assets that a community spouse should be able to maintain and retain, in those situations, MassHealth and or Medicaid is going to allow the community spouse to tap into the assets of the institutional um, or applicant spouse to make up the difference so that the CSRA minimum is met. As of 2021, the minimum CSRA for a MassHealth community spouse is $26,076, and the maximum is $130,380. Now, the maximum is pretty easy to understand. That's the most that a community spouse can retain in terms of dollar value assets. Um, but that amount can be increased if needed by going to a fair hearing and presenting a judge with exceptional circumstances that should allow that amount to be increased. Now, when I say exceptional circumstances, it's pretty strict. It has to be something that really needs to be paid for, like a high cost medical treatment that is going to exceed the limit or something along those lines. So in addition to rules about how much assets a community spouse can retain or maintain, MassHealth also has rules regarding the amount of income a community spouse can maintain. And then they really have something called a minimum monthly maintenance needs allowance, or MIMNA. And what that represents is the minimum amount of income that should be coming into a community spouse in order for them to be able to pay their bills and live their life while the institutionalized spouse is in long-term care. To determine a community spouse's MIMNA, MassHealth is going to add together three things. They're going to add together the current MIMNA amount that's been set by the federal government, and that's the minimum amount. And that is, as of August 2021, $2,177.50. So you're going to take that, you're going to add to it something called an excess shelter allowance, and you determine the excess shelter allowance by adding up all the property taxes, rents, mortgages, insurance, condo fees the community spouse has to pay, and subtracting $646.50 from that. So once you have that number and you've added to the MIMNA, you're going to then add what's called the applicable standard deduction under the food stamp program for utilities. And that changes every year as well. And just as a quick note, remember how when a CSRA community spouse, when a community spouse doesn't meet the minimum CSRA amounts and can then tap into the assets of the applicant and or institutional spouse to make up the difference? Much like that, when a community spouse doesn't meet the MIMNA, what MassHealth and or Medicaid is going to allow that spouse to do is tap into any income and or assets the institutional spouse or the applicant spouse has to make up that difference. Now that we have a little bit better understanding of the community spouse resource allowance and the minimum monthly maintenance needs allowance, I just also wanted to touch upon a couple of different situations that can sometimes occur during the MassHealth application process and how those situations impact the spouse that is applying for the long-term care benefits. And the first situation I want to talk about is spousal refusal. And as you may have guessed, what spousal refusal is it's when a community spouse simply refuses to cooperate with the process of obtaining the institutionalized or applicant spouse long-term care benefits. what MassHealth does in these situations is they don't punish the institutional spouse, the institutionalized spouse, for their community spouse's failure to cooperate. They don't do that. What they do instead is they'll still allow the institutional or applicant spouse to obtain benefits, but they also ask that that spouse then assign to MassHealth the rights to seek any levels of support that the community spouse otherwise would have owed to the institutional spouse. And they do this because it simply wouldn't be fair for one spouse to be denied long-term care benefits because another spouse is just simply refusing to cooperate with the situation. In addition to spousal refusal, there are sometimes situations where a married couple thinks that the best way to obtain MassHealth long-term care benefits for the needy spouse is for them to divorce and for the community spouse to basically take all the assets from the divorce agreement. Now, this is not a great idea, and I implore anybody who is thinking about divorce as a solution to qualifying one spouse for MassHealth's long-term care benefits to consult with an attorney before they make any steps towards getting a divorce, because it's not the panacea that some people may think it is. Because what MassHealth is going to do is, just like when there's a spouse is refusing, they are going to ask to be given the rights to obtain additional assets and or income from the divorce agreement if they review it and determine that it was unreasonable or that it was done just simply to get MassHealth and or Medicaid benefits. So again, divorce, aside from the moral question about just divorcing to obtain some benefits, it really, again, is not the panacea that some may believe it to be, and you should not proceed with that course of action until you've spoken to an attorney and gotten some good advice. And in situations where there's a prenuptial agreement, just like a divorce, what MassHealth is going to do is they're going to review that agreement to determine if it's reasonable, and if it's not, they're going to come after the spouse that got the better end of the deal. So I just want to thank you for watching today's video by CMM Legal Services on how MassHealth treats the assets of married couples. So if you have any questions, any concerns, any comments about the video, please feel free to reach out to CMM Legal Services either by phone or email. The email is info@cmmlegalservices.com, all one word. By phone, 978-806-0881. And on the web, you can find us at www.cmmlegalservices.com. That's all one word, CMMLEGALSERVICES. Thanks, everybody.